All right, good morning, guys. I see Fish and Golf has first blood again. Get you some, brother. And, ridiculous news out of Colorado. I don't know that we've become a third world country yet, but it is certainly the case that one party in this country is hell bent on making that happen. So let's dig in and talk about this. Okay, guys, sorry about the long intro there. I was trying to pull up the actual text of the ruling that we're about to be talking about. Fish and Golf says Chicago mayor shipped 3 busloads of immigrants out to western suburb near me yesterday at about 300 of them. You say, good God. Yeah, I ain't gonna lie, guys, it's getting scary in America. This, however, this ludicrous court decision out of Colorado, I think I can put your minds at ease somewhat on this. But let's be real. The decision is psychotic. That's the most coherent and intelligible thing anyone could say about it. So just for GP, here's the headline from CNN: Trump is ineligible for office under 14th Amendment's insurrection ban. Colorado Supreme Court rules. Now, that's a little misleading. There are several articles from other papers that are dramatically more misleading, which say things like Trump has been removed from the ballot. But let's take a look at the actual text of the Supreme Court, the Colorado Supreme Court ruling, which is uncooperative. Come on now. There we go. That's what I'm looking for. Now, this is a 213-page document. This is something that they do on purpose, right? 213 pages of document because, frankly, the government doesn't want you to read. They want to prevent you from reading, right? And we don't have time to go through this whole thing this morning. But let me show you if I can even find it, right? That's another part of the problem is you have to go digging through there to even find it. So, but here's the actual text. And to be clear, what they have said is that for one, a lower court determined that the so-called insurrection clause does not apply in the case of Donald Trump for a myriad of reasons, not least of which that the president doesn't appear to be eligible for exclusion by way of the 14th Amendment, Section 3, which I'll get to in just a minute. But there's also the challenge legally to the facts in question. And according to this court ruling, what they're saying is that Donald Trump, because he led an insurrection, is ineligible to run for office. There's a shitload of problems with that, not least of which is the claim that Donald Trump led an insurrection. One can make that claim and even offer some evidence to support the claim. It's flimsy evidence at best, but let's not forget, Donald Trump not only has not been convicted of the very specific crime alleged by the statement he led an insurrection, that crime being the involvement in insurrection under the Insurrection Act, which is a specific and detailed crime, an activity which is so clearly not related to the events of January 6th, but it's so clearly unrelated to the events of January 6th that not only has no one been convicted of that crime, the crime itself has not been alleged in any indictment of any of the hundreds of January 6th protesters who have been illegally and unconstitutionally remanded into solitary confinement in many cases for years without any adjudication, without even bail hearings. Right? The constitutional violations, the depravity there is just alarming. Fat Guy in Bed asks what books I have behind me. I have a copy of Such Troops as These, The Genius and Leadership of Confederate General Stonewall Jackson, an excellent book on military strategy. The Source Book of Magic, which is a comprehensive guide to neurolinguistic change patterning and programming, and Robert C. Solomon's Existentialism, which is a collection of works by people like Heidegger and Kierkegaard. And I highly recommend all three of those books. And Sergeant Major points out that's excellent to point out there. This Sergeant Major points out that the Colorado Supreme Court is ignoring the FBI determination that no insurrection occurred. You guys need to remember that word insurrection, as it is applied to the January 6th event, is pure branding. This is public relations activity. Right? It's like slapping a new and improved label on a box of cereal where the law requires only that the packaging be changed. So it is literally sufficient under the law to claim that your cereal product is new and improved if you add the label new and improved to the package, because the addition of the label new and improved is a change that is subjectively an improvement over the previous iteration. And that subjective claim can be objectified with the argument that the inclusion of the new and improved label increases the likelihood of sales, and therefore the package is superior to its predecessor. The use of the word insurrection, a totally fallacious application in the case of the January 6th events, and most especially fallacious when considered against the other events of 2020, BLM riots, the May 29th insurrection, where BLM, Antifa, and Democrat voters firebombed the White House and the church across from it, the burning of federal buildings, the establishment of the CHOP, CHAZ, and other so-called autonomous zones. That insurrections occurred, or let's be real, it was organized. It was an insurrection conducted by the Democrat National Committee, their supporters. That those events occurred throughout 2020 is obvious. But the language isn't being used there. Now, in this case, the Supreme Court in Colorado, so we're talking state Supreme Court, has overturned a lower court ruling that said that obviously Donald Trump cannot be excluded from the ballot under these circumstances, under these accusations. Donald Trump, much like anybody else involved in January 6th, has neither been indicted, let alone convicted of the crime of insurrection. So it seems on the face of it right there, there's no mechanism by which he can be removed under these terms. Now let's clarify something real quick. Here is the language of the 14th Amendment, Section 3, where it says, "No person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such a disability." And now it says senator or representative. It says elector of the president and vice president, or hold any office, civil or military, under the United States or under any state. One can argue, perhaps, that the language "hold any office, civil or military, under the United States," but there are a couple of problems with the language as far as trying to apply this to the president. It does say civil or military. The president is the only office which is civil and military. Everything else has a clear distinction, and there is in fact a reason for that. But it's very clear: senators, representatives, electors, right? So the current prevailing wisdom in legal conversations on this topic is that Section 3 does not apply to the president. Now, here's the other piece that should give your heart some hope. The obscenely activist Colorado Supreme Court, this is 7 justices, voted 4-3 to say that they want Trump removed from the ballot. And they have stayed their own decision until January 4th, with January 5th being the deadline for the Colorado Secretary of State, I believe, to finalize the ballots for printing for the Colorado primary. So this should give you some hope. They have stated, and according to the text of the decision, until January 4th, or or instruction comes from the Supreme Court of the United States. They haven't said what Supreme Court, or I'm sorry, what instruction, just that any instruction come from the Supreme Court, which is to include that an appeal is filed. So if Trump just says, yo, I want to argue about this, which he already has, please believe they were basically, Trump's lawyers were basically sitting on a filled motion to put in. And so basically, yeah, the second it was filed, the appeal was put in place. Sorry, I had to clean my glasses for a minute and read this. Xander says, that's the only issue this case was hearing, whether Article 3 applies to the president. Now SCOTUS will take it up and say, of course it doesn't, and it'll go away. Yes. And so my expectation is that we're going to hear a lot out of the Supreme Court over the next couple of months. That's going to include things like obviously vitiating this ridiculous ruling. And I suspect that we're going to see a lot of January 6th victims either being released and having their charges dropped, or in some cases, I suspect you'll see convictions overturned. And if I had my way, I would see restitution paid to the victims of the Democrat national conspiracy to defraud the American people. We have all been harmed and aggrieved by the national organized conspiracy of the Democrat Party over the last at least decade and a half. But when you look at people like the J6th accusees, the January 6th victims, you're looking at people who haven't just been aggrieved in the way that most of us have been nationally, loss of our rights, the loss of our wealth, the theft of our private properties, etc. But you're talking about people who have been tortured in an absolutely unjust violation of their constitutional rights. They've been straight up tortured. Now, there are some arguments going on right now also. Part of the argument, let me put a pin in that real quick. I want to get to the article, and it's gonna bring that up in the article, and I'll get to that in just a second. So, Trump is ineligible for office under 14th Amendment's insurrectionist ban, says the Colorado Supreme Court. In a stunning and unprecedented decision, the Colorado Supreme Court on Tuesday removed former President Donald Trump from the state's 2024 ballot, ruling that he isn't an eligible presidential candidate because of the 14th Amendment's insurrection ban. I already showed you how this statement is false. It's not even notionally true. They've issued a ruling that says they will have him removed if the Supreme Court doesn't say stop, dummy, which we fully expect the Supreme Court to say stop. No, okay, let me back up real quick. We should fully expect the Supreme Court to say, whoa, stop it, dummy. But I will reference you back to the Texas originating lawsuit against the several states that illegally changed their election policies, laws, and procedures without the involvement of the legislatures. And the Supreme Court did duck on that. The Supreme Court said, we're not going to hear it. And of course, any controversy between states can only be handled at the Supreme Court, legally speaking. So I don't have ultimate faith in the current Supreme Court. I don't. It has several painfully captured activist justices, and while it shows that there is a conservative majority, it's heartwarming that there's a conservative majority on the court. It's not a it's not a courageous conservative majority. They have been very weak on several things so far. But Xander says, I'll wager the SCOTUS will vacate this 9-0, and I suspect you're correct. But I don't have ultimate faith in that Supreme Court. They have been very weak in the past on some important topics. So it says the 4-3 ruling will be placed on hold until January pending Trump's appeal to the U.S. Supreme Court, which could settle the matter for the nation. And yes, I suspect it will. Danny says 8-1, and that wouldn't surprise me at all, especially with Ketanji Brown there. It would not surprise me at all to see somebody like a Ketanji Brown write a dissent that, because she's that kind of leftist that's just vulgarly unself-aware, she's going to write a dissent that makes all these arguments about why Trump should be removed from ballots and the 14th Amendment Section 3 should apply to him. And they're going to unironically include essentially everything that Joe Biden has done as vice president, for which he maybe should have been excluded from the ballot, or at least be now impeached for treason, high crimes, and misdemeanors. Now, treason, there's no declaration of war. Treason's a little strong, but it very well might be that way. President Trump this is from the decision. President Trump did not merely incite the insurrection. Okay, full stop. That sentence first presupposes that there was, in fact, an insurrection. That is a fact in dispute. That is a claim in controversy. And I would actually go so far as to say that that claim is no longer in controversy because the FBI has issued a finding that there was no insurrection. Right? So right off the rip, the mere premise of their accusation and argument is Trump did not merely incite the insurrection. Well, if an insurrection did not occur, then Trump could not have incited it. But they go on to say, in their unsigned opinion, by the way, fucking cowards, even when the siege on the Capitol was fully underway, let's remember, guys, this so-called siege on the Capitol lasted for barely over an hour. And we now know from the videos that have been released from the Capitol building that what a large part of what really happened there is there were actually two events on opposite sides of a building so large that the two events were likely not even aware of one another. On one side, there was violence and rioting, and on the other side were actual Trump supporters without federal intervention. But they go on to say, even when the siege of the Capitol was fully underway, he continued to support it by repeatedly demanding that Vice President Mike Pence refuse to perform his constitutional duty, and by calling senators to persuade them to stop counting of electoral votes. Excuse me. Excuse me. Yeah, Xander Mack points out unsigned because judges don't want a reversal on their record. Correct. And every judge, every one of these judges should be considered to have a reversal on their record as soon as this is defeated. I'm 100% with you there, Xander. You're correct. I'm sorry about that. I had some hiccups there. So they say these actions constituted overt, voluntary, and direct participation in the insurrection. But again, we now know conclusively, and this is an important fact point, because the FBI determination predates this court ruling by over a day. We now know that there was no insurrection. And they say that we conclude that the foregoing evidence, the great bulk of which was undisputed at trial. Oh, was it? Oh, was it? Or was this more like an Alex Jones / Rudy Giuliani situation where the defendant was explicitly forbidden from presenting evidence and then directed a default judgment on the basis that they had failed to produce the evidence which the court ordered them not to produce? This is psychotic. There is no more justice system in the United States of America. Even if the Supreme Court comes down on the other side of this, what's happening here is, the Supreme Court comes down on the right side, vacates this absurd ruling, and I do fully expect that that's what's going to happen. The fact that these judges feel safe, feel like there will be no consequences. And I'm not calling for violence, right? I'm not saying that we should take up arms and go solve these judges. The fact is, these judges feel safe from professional and legal ramifications of their clearly unlawful activity. Xander asks, was that a hypothetical or did that happen in this case? Was he excluded? That's a hypothetical. I don't actually know in this particular case, Xander Mac, but it is the prevailing trend in cases of this sort currently. It would surprise me not at all to find that the so-called evidence, which, and like I said, the evidence proved to the FBI that there was no insurrection. So the idea that they heard evidence at all is, it's absurd. But here's the one that I started to say something about the free speech thing a minute ago, and I said I'd get back to it when it came up in the article. Here we go. The court rejected Trump's free speech claims, writing, President Trump's speech on January 6th was not protected by the First Amendment. His speech was not protected by the First Amendment? Excuse me. I believe that President Trump, according to your own accusation here, demanded that Vice President Pence refuse to perform his constitutional duty, and by calling senators to persuade them to stop the counting of electoral votes. We saw in the 50s in Hawaii, they sent an alternate slate of electors. That's the thing that Donald Trump's accused of doing. They changed, and this was something the Democrats did, and it was okay when the Democrats did it. And they decided to reject the outcome of the state election in Hawaii and send alternate voters to influence the outcome of the election. The thing that Donald Trump suggested, the use of the alternate electors sent by the individual states, is not unprecedented. It is not illegal. It has happened. It has happened successfully. And that he asked the vice president and senators, assuming that it's the case that he made the specific nebulous request that's being asserted, then I would go so far as to say, fuck the speech question. The First Amendment also guarantees citizens, which the president necessarily is under the law, the right to petition the government for redress of grievances. What we are seeing in this country now is a Department of Justice that has decided, essentially by political fiat, to simply abolish the Constitution. They must be reminded that the Constitution does not grant us rights. The Constitution restricts the government from interfering with and harming those rights. The Constitution is a document of negative liberties. It offers the grant of some authorities, but authority necessarily interferes with liberty. the very specific individual authorities enumerated in the Constitution are themselves individually vitiated when they interfere with the enumerated rights against which the government is prevented from interfering with. That's an important distinction. So, I got a couple little more things that I want to touch on with relation to this topic before moving on. Charlie Kirk, of course, said it best. Breaking Colorado Supreme Court just removed Trump from balloting in 2024 based on the 14th Amendment's insurrectionist ban argument that has failed in every other half-baked legal challenge. Let me get to that real quick. But Charlie Kirk points out, yes, this is election interference. One of the headlines, one of the narratives, I'm going to run a little over this morning. One of the big narratives that's being run right now is essentially that that there are challenges in several states. There are challenges in several states where people are bringing lawsuits to have Donald Trump removed from the ballot based on the insurrectionist thing. But it's important to understand a little context with that. And here it is. There's this shithead attorney named Castro who's running for the GOP presidential race, who is the one that has filed. And he's been filing those challenges specifically in states that Trump won. And that's another important, and all of these challenges are failing in these, obviously, in states that Trump won. But you got this one guy that's filed like 8 or 9 of these motions in places like South Carolina, North Carolina. There's a list of them here. Where's the list? Oh, he filed one in Florida. But he's filed in a bunch of places where Trump won, and it's purely a PR maneuver, like I was saying before. But it gives the Democrats, it gives the media and the press that little piece of something for the narrative. Oh yeah, this is going on in states all across the country. People are filing these lawsuits, and here's the other piece of it. These are civil actions. The case that the Colorado Supreme Court is ruling over from a lower court that did determine that Donald Trump is not eligible for removal under the 14th Amendment. That case was a civil action filed by a partisan political group on behalf of 6 individuals. And it's a civil action. The closest they have to a conviction, like I was saying earlier, there has been no indictment or conviction for the crime of insurrection. The closest they have to a court ruling on that is in a civil action. One judge referred to Trump as an insurrectionist in the course of an official proceeding, in a civil action, not a criminal case. Right? Still no indictment, still no charge. There was no insurrection. That what happened on January 6th can be called an insurrection is a fucking abuse of language. A psychotic one at that. Now, Vivek did the right thing, I think. This is interesting, and I'm already running over, so I'm not going to play the video. Guys, go, here, I'll drop the link on Twitter in the chat there if y'all want to go see Vivek's little 2-minute video where he said that he's gonna pull out of the Colorado primary, and he calls on every other GOP candidate to do likewise. But this surprised me. I was pleasantly surprised to see this also on Twitter in response to Vivek's tweet. The Colorado Republican Party replied to Vivek threatening to withdraw from the Colorado GOP primary by saying, "You won't have to, because we will withdraw from the primary as a party and convert to a pure caucus system if this is allowed to stand." So, we were already saying the Supreme Court is likely to come in and just throw this down and be done with it, and that'll be the end of it. And likely what will happen is not only will the Supreme Court do that, but when they do that, that will shut this crazy shit down across the country for the rest of them. But the Colorado Republican Party is making the absolute right move here. They're saying, no, we are a private organization, we're a private party, and if the state has decided that they're going to interfere, then we will remove the state from the equation by removing ourselves from the state's equation. You won't have to withdraw, because we will withdraw from the primary as a party and convert to a pure caucus system if this is allowed to stand. And frankly, I haven't had time to give that particular activity a great deal of thought yet, but I'm inclined to say I would like to see this happen in every state in the country. Generally, just every state GOP say, you know what? You're a bunch of corrupt shills. We wash our hands. We're done. We're going to back out and be a pure caucus. We will choose our candidate without the state's involvement. Done. Done. Because frankly, I cannot think of a single aspect of government at present that I would not happily abolish without warning. I mean, switch it off. Because I cannot think of one aspect of our government today that is not only corrupt, but so corrupt that it has become destructive of those means which we think of as liberty and prosperity. And when I say we think of as liberty and prosperity, these are words that have meanings. And those meanings matter. Just like male and female, definitions are a core part of the coterie of that language. And they matter. So, I'm going to go ahead and put a pin in it there. My heater ain't working right in my pick-em-up truck, and I got to go get it fixed this morning because, y'all, it's cold. So, y'all be safe out there. Thanks for watching. We love you, and we will see you tomorrow.